This video is about crime, bail, and safety in Canada. You are going to hear two very different views from Parliament. One side, Roman Baber is a member of Parliament who is raising hard questions about crime, bail, and public safety. He is speaking for victims, families, and communities who feel the system is failing them against and says the system is too soft and letting dangerous people walk free. The other side, Sean Fraser is a federal minister defending Bill C14. He is explaining why the government believes the law focuses on fairness, context, and public safety without overusing jail, and defending jail should not be used for people who are not a real threat. In this video, you will hear about young offenders, gang violence, missed court dates, and real families who lost loved ones. You will hear why some offenses are not being punished and why the government says that is necessary. This matters to you because it affects public safety, your community, and how safe Canada really is. It affects taxpayers, parents, and every Canadian who expects the law to protect them. Here, a small glimpse of the conversation where a member of Parliament mentioned young offenders and gang violence, especially in Toronto.
New prevalence of young offenders, especially in gang violence, in Toronto is very troubling.
Next, you will hear where a member of Parliament challenges the government and questions why failing to follow bail rules is not being taken seriously. The Speaker says a major law has failed Canadians. He talks about people who miss court dates, break bail conditions, or ignore court orders. He says these offenses are often removed from court and face no real consequences. The question being asked is simple but serious. Why has the government not fixed this in the new law? This affects you because when court orders are not enforced, public trust drops. Communities feel less safe, and people start to believe that the law does not apply to everyone. Now listen carefully.
One of the big failures of Liberal Bill C75 is that it created a diversionary regime for offenses involving failures to comply with court orders. So offenses such as failure to appear, breach of undertaking, or even breach of bail conditions may often go unpunished. Basically, C75 allows Crowns to divert or to remove those offenses off the docket. This has been a spectacular failure. Why is this not addressed in Bill C14?
Why should some people who break bail rules not go to jail? This question matters because bail rules exist to protect everyone. When court rules are not followed, people lose faith in the system. If some people can break the rules without consequences, then the law stops feeling equal. This affects every person living in Canada. It affects workers coming home at night. It affects communities that already feel unsafe. It affects parents who send their kids to school. When rules are not applied properly, small problems can turn into big dangers. Missed court dates can turn into repeat offenses. Ignored bail conditions can lead to real harm. You are going to hear the minister explain why some people miss court for reasons beyond their control. He will talk about low-income Canadians, lack of childcare, and no transportation. He will say that not every bail breach means someone is a threat to public safety. But this raises a big question for Canadians. If rules are flexible, where is the line? And who decides when public safety comes second? Key points need to listen carefully. When bail rules are not enforced, public trust collapses. Communities feel less safe when offenses have no consequences. Low-income struggles are real, but public safety affects everyone. If the law is not applied, equally Canadians pay the price.
There are dangerous people that need to be incarcerated because they pose a public safety risk. The circumstances surrounding an administrative charge can vary significantly. In some instances, particularly when you're dealing with low-income Canadians, there may be somebody who missed a court date because they had no access to childcare, there's not public transportation, and they can't afford a car. I don't want somebody in those circumstances to necessarily be incarcerated when they don't pose a public safety threat.
Does Bill C14 really stop violent repeat offenders? This question matters because Canadians expect dangerous people to be kept away from the public. When someone is violent again and again, people want to know if the law is strong enough to stop them. If repeat offenders are not dealt with properly, fear spreads in neighborhoods and communities. It affects how safe you feel using public transit. It affects small businesses, families, and seniors. When violent people return to the streets, everyone pays the price. You are going to hear the minister say that Bill C14 does target violent repeat offenders. He explains that the law includes stronger penalties for people who are both violent and in contempt of court. He says this approach protects public safety without jailing people who are not a real threat. Key points need to listen carefully. Repeat violent offenders create fear and instability. Stronger penalties sound good, but results matter more. Public safety must come before convenience. Canadians need to see real change on the streets.
Now, if there are people who are violent repeat offenders who are also acting in contempt of court, there's actually increased penalties included in Bill C14, which is a better way, in my view, to deal with that. So making sure we don't use too blunt an instrument to incarcerate people who pose no public safety threat, but through life circumstances of which they're not in control of, find themselves before the court in these kinds of proceedings is an important thing that we need to allow courts to deal with.
Can a life lost be prevented by stronger bail enforcement? This question matters because this is not just about laws or politics. This is about real people and real families. When someone dies because a dangerous person was still on the street, Canadians ask one hard question: why? This affects every person living in Canada. It could be your child, your friend, or someone you love. You are going to hear about a 28-year-old woman who lost her life in a car crash caused by a drunk driver. You will hear that there was already a warrant for his arrest. You will hear that he had breached bail conditions before. This part forces Canadians to ask whether this tragedy could have been avoided. And if the system failed, who is responsible? Key points need to listen carefully. A young woman lost her life needlessly. The offender had already broken bail rules. Enforcing bail could save lives. Justice fails when warnings are ignored.
Mr. and Mrs. Best, the parents of Kelly Verry, 28 years old, who was killed in a car crash last January by a drunk driver. At the time of this tragic incident, there was a warrant for his arrest for breaching bail conditions. In fact, that was not the first but the second time that he was wanted for breach of bail. He had already breached before. The mom, Michelle Best, said to us that Kelly's death was completely avoidable. Let's talk about that as a philosophical issue.
Does Bill C14 really give answers to grieving parents? This question matters because behind every crime is a family that suffers. When parents lose a child, they deserve honest answers, not just policies and words. Canadians want to know if the law is strong enough to prevent future tragedies. This affects every person living in Canada. It affects how much trust people have in the justice system. When victims' families feel ignored, people start to believe that the system cares more about process than people. You are going to hear a direct question asked to the minister about what he would say to parents who lost their daughter. You will then hear his response, where he acknowledges the pain and says no law can bring a child back. He speaks about the limits of the criminal code and the deep loss many Canadians have felt. Key points need to listen carefully. No law can undo the pain of losing a child. Families want accountability, not just sympathy. Canadians expect laws to prevent future tragedies. Justice must balance compassion and consequences.
What would you say to Kelly's parents about why Bill C14 does not go far enough to punish those who breach bail conditions?
First of all, that there is no tragedy that can compare to someone losing their child. There is no answer that you can give in the criminal code that will bring someone back to life. And it is a pain that too many people in this country have felt personally and know deeply.
Is the law at fault or how the system used it? This question matters because Canadians need to know where the failure really is. If the law is strong but applied poorly, then the problem is accountability. If the law itself is weak, then the problem is policy. This affects every person living in Canada. When responsibility is unclear, mistakes keep happening. And when mistakes keep happening, public safety is at risk. You are going to hear the minister say that the person involved was released with Crown consent. He says this was not a failure of the rules themselves, but how the case played out. He argues that Bill C14 is designed to deal with dangerous people who breach bail conditions. Key points need to listen carefully. Blame shifts between law and enforcement. Crown and courts play a critical role. Dangerous people must be identified early. Public safety fails when responsibility is unclear.
My understanding of that case is that the person was actually released on Crown consent, so I don't understand that that was a shortcoming with these specific rules, but perhaps with how things played out in that particular instance. If there are dangerous people who are also breaching bail conditions, that is absolutely something that the court should be considering. Making sure that we're dealing with people who pose that public safety risk is precisely the kind of thing that I believe Bill C14 will do.
Are young violent offenders being punished enough? This question matters because youth crime does not stay in the past. When young offenders commit serious violent crimes and return quickly to the streets, communities feel abandoned. Canadians want to know if the law protects the public or protects the offender. This affects every person living in Canada. It affects neighborhoods dealing with gang violence. It affects parents worried about their kids. And it affects victims who feel justice is not done. You are going to hear a challenge about youth sentencing laws. The speaker questions why serious crimes like second-degree murder have strict sentence limits for youth. He argues that after serving short sentences, some offenders return and terrorize communities. Key points need to listen carefully. Serious youth crime has real consequences. The offender had already broken bail rules. Communities feel left unprotected. Public safety must apply to all ages.
New prevalence of young offenders, especially in gang violence, in Toronto is very troubling. But there is no sentencing reform in Bill C14 with respect to young offenders. For second-degree murder, for instance, the Youth Justice Act limits custodial sentences to 4 years. And then they come out and terrorize our community. Why doesn't Bill C14 increase sentences on young offenders?
Why does Bill C14 not fully address youth crime? This question matters because youth crime is a growing concern in many Canadian cities. When young people are involved in serious crime, Canadians expect the law to respond clearly. If the system does not address youth crime properly, the problem can grow over time. This affects every person living in Canada. It affects community safety today and tomorrow. It affects how early criminal behavior is stopped or allowed to continue. You are going to hear the minister explain that most feedback during consultations focused on adult crime. He says youth criminal justice was not raised as strongly at that time. He also talks about a different approach, targeting adults who recruit young people into crime. Key points need to listen carefully. Youth crime was not the main focus of the bill. Prevention targets recruiters, not just youth. Communities want immediate safety. Long-term solutions must start early.
The process of engagement that we undertook identified certain reforms that disproportionately fell into the category of those which apply to adults. We weren't necessarily doing the same, hearing the same level of feedback when it came to youth criminal justice, though there are some elements that we touched in Bill C14. One particular piece actually subsequent to the development of C14 that we did hear was the need to ensure that we're targeting people who would recruit young people into crime.
Should Canada do a full review of youth criminal justice? This question matters because youth crime is not a short-term problem. Decisions made today will shape public safety for years. Canadians want policies based on real experience, not guesswork. This affects every person living in Canada. It affects future generations. It affects how early intervention and accountability are balanced. You are going to hear a call for a deep study on youth criminal justice. The speaker invites experts, professionals, and Canadians who work in this area to help find real solutions. The message is clear. If Canada wants real change, it needs serious study and action. Key points need to listen carefully. Youth criminal justice needs expert input. Long-term safety requires serious study. Policy must be based on real results. Canadians deserve better solutions.
Mr. Fortin actually is one of the people who first raises this issue with me, and it is present in Bill C14. So this committee will have an opportunity to consider that particular issue. But if the committee wants to advance further work on youth criminal justice, I would welcome a study that benefits from deep engagement and expertise of Canadians who spent their careers identifying solutions in this space.
Thank you, Minister. Thank you, Mr.
This debate showed two very different visions for justice in Canada. One side warned that weak enforcement puts lives at risk. The other side argued that the law must be careful, fair, and context-based. What is clear is this: public safety, bail, and youth crime affect every Canadian. These are not just political arguments. They shape how safe our streets are and how much we trust the system. Subscribe to Canada Insight Network for more latest breakdowns, Canada Current Affairs, House of Commons debates, immigration and permanent residency updates, and real discussions that affect your life in Canada.